Yes, Mr. My lord, I beg to mention a writ petition. We have filed it yesterday. Can it be listed on Monday, my lord? Along with the IA, my lord. The person is in detention.
Wednesday, 25th.
My lord, deep lord.
Yes, Your Lordship. Sure, I beg to mention item number 23, Lordship. Your Lordship, it was filed earlier, Lordship, by another council, Lordship. I have come newly, Lordship. So, Lordship, I want on an adjournment in this case, Lordship. I could not prefer because of the communication gaps, Lordship. It was earlier filed by another council, Lordship. So I have come later, Lordship. I put an instruction and otherwise, Lordship, perhaps I have to leave the case, Lordship.
When do you want?
Lordship,
When do you want?
Lordship, any day after 1 week or 2 weeks, Lordship.
After 2 weeks, the vacation will start.
Then, Lordship, before vacation, after vacation, Lordship, no urgency is there, Lordship. That's I have to take proper instruction, Lordship.
24th of October.
24th, Lordship. Lordship.
May I please, Your Lordship? Item 16, Your Lordship. A peculiar situation arises in this case, Your Lordship. The petitioner has already been arrested, Your Lordship. So I need to file additional affidavit and IA, Your Lordship, for bail.
The prayer will be counsel for the.
May I please, Lordship? I beg to mention item number 22, my lord. Kindly adjourn for 2 weeks now.
Why?
My lord, I have some difficulty today, my lord.
With the matter, this is 2018 matter,
Yes, my lord.
not at this stage. Let the matter reach.
My lord, I have no brief with me, my lord. Because senior is
See, at this stage not possible. Let the matter reach.
obliged.
May I please, Your Lordship, Lordship, I want to mention regarding listing of 2 IA for bail next week on any date, Lordship. Friday,
Division bench.
yes, Lordship.
Where are they? Where are the detainees? Where are the detainees? Which jail or in detention camp?
It's for criminal appeal, Lordship. IA in criminal appeal today, it was, notice was given that
26th.
much of this.
May I please, Your Lordship? I beg to mention for lifting IA for correction.
Which bench?
My lord,
Which bench?
DB,
Criminal matter or?
FT matter.
But this order was passed by K.R. Surana and through Lordship. My lord, there is a mistake, my lord. Only, my lord, Borpeta, Bozali, it would be Borpeta, my lord, for correction. On 25th, my lord.
Okay.
Obliged.
When did you file?
My lord, I filed it already numbered, my lord. Obliged.
May I please, Your Lordship? My lord, the matter may be passed over for time being. My senior is on lake, my lord.
Someone of you go to the records. You take it up to some time.
Obliged.
My lord, on the last occasion, my status report was asked for my status report as regard the investigation.
Mr. Sharma?
Yes, Lordship. Received this paper.
এই মাত্র চাইছো এই মাত্র চাব দিছে মুরগি পান করে চাই আছে না এটাই আছে তিনটা আছে এই মাত্র পাইছো থাকবে আগে তো এই চাই আছে newspaper পাঠাচ্ছে publication গুলো জানলে আর রিপোর্টেড by now one case of death has been re-examined and continued and
What is the applicant status of investigation? Only the second para.
मतलब para two मतलब the in newspaper मतलब it is already published below. Dainik Janamabhumi and the Sentinel. Yes, sir. Status report has been updated.
Order, I think, 26/7.
So a detailed report was submitted on last occasion. On last occasion, मतलब the detailed report was submitted.
Do you have the copy?
I have one. I. Did you? It was. Lordship has observed there was a supervisory note to the IO also. I have a copy. I have. Salman. Salman की है कॉपी वाला से नहीं पहले ठीक है हमारे पर छोटे पैसा तो दिया पैसा तो जमा कैसे डब्ल्यू से नंबर तो मिल सकता
Done. Have you checked up in the, let us say, the government hospitals or some places like that? What steps have you taken to find out the status of the missing person?
Well, they have
Really publishing in the newspaper, the police will have to take some steps to find out. What is the report from the hospital, government hospital? Whether any person of this description was ever admitted? Have you inquired the people of the neighborhood of that area, Korea
yeah.
area where the incident took place?
Because that has been done. That has been done.
These are the reports, latest report.
Mr. Nath, what brother is asking is very clear, because the report that you have submitted, it doesn't indicate anything.
Well,
Accepting the asking of the CDR, in fact, there was no queries made with the people of the neighboring people where the car was found.
no, the neighborhood people, they have been asked about, if lordship kindly comes to the supervision note of the SP. In the,
Sorry, which page?
well, in the
Supervisory.
supervision note is given by the SP. In that note, kindly see, she has serial number 3, action taken by the IO, he has reflected. Serial number 3, serial number 6, this has been done,
So whether these directions by the SP has been complied with by the IO?
Yes, I'm told that this is followed.
What is the progress from the CDR and the IPR data?
They said that no clue has been found. There is no clue. And so I specifically did not ask about the hospital team, that I'll indicate that whether any person is there or not. That I have not asked.
He has disappeared. So process of investigation, these are the first things we
Correct.
find out.
Correct. This serial number 7 in the supervisory note, that lordship may kindly see. Ultimately, in the present report also, the present report which we received on 17/9/24, she was again re-examined, and her statement under section 180 of BNSS was recorded again. There is one difficulty they face, because the incident took place on 13/12/23, and the information was given to police little lately. In fact, the next day. Well, no, the car was, in fact, they have informed that
What have been recovered?
no, no,
Dead or alive?
no, that is not known. As per my information, that is not known. That is not known.
But then you are praying for a compensation. Page 12, your prayer is for compensation for 10 lakh.
Yes, my lord. There is a prayer, my lord, compensation.
Which means you know that he is probably not alive anymore.
My lord, missing, my lord,
See, you know the
my lord.
law of evidence.
Yes, my lord. 7 years required, my lord,
7 years.
to deem to my lord death, my lord. That 7 years required. My lord.
Then you already started paying for compensation.
From the date of missing, my lord, the year to 1 year is not completed. My lord.
Then
But their basic grievance at page 24, kindly see, of the writ petition. They said that, I have lodged an FIR on 14/12/22. Possibly it should be 23, regarding missing of my son, Muhammad Anarul Islam, aged about 22 years, with effect from 13/12/23. The case is numbered as so and so. Finding no response from the Rupohiyat police, I have informed the SP for recovery of my son by written petition dated 24/1/24. The matter has been taken up by the crime branch Nagaon SP so and so, yet no arrangement of investigation has been done as on today to recover my son. That's so their grievance is that police has not started the investigation, done nothing. That is their grievance. But in response to that, we have submitted a status report that no case has been registered and they have investigated. Persons were arrested, the persons were called, they were interrogated, their statements are recorded. Those things haven't done. Three persons were arrested, they were sent to judicial custody also.
You are fighting for the heaviest corpus. You're not trying for heaviest corpus. It's not a heaviest corpus.
No, this is not.
Then why-
They have, it was, he was not taken by the police. His custody was not taken by the police.
Then-
So, my lord, the question of habeas corpus, my lord, not arise, my lord. Only, we are only on the investigation by the police.
Then it should be referred to the single bench. Why have you filed it before the division bench? It's not a habeas corpus. You have not made for the right of habeas.
I would humbly submit. Their main grievance is as regard the police inaction, that no investigation has been started. We have indicated that
That
it
is
is
the
going on.
domain of the civil bench.
But even they can approach the concerned judicial magistrate, CJM also, under the provisions of the law.
That view the learned single judge will give whether the writ petition is to be maintainable
Correct.
or.
True.
Remedies available under the criminal procedure.
Yes.
PNS.
Correct.
But so far as this bench is concerned, there is no writ of habeas corpus. We have not prayed for a writ.
My lord,
This is not a case of,
only we are on the
Police action.
police action, my lord.
it's not a case of police action. It's a case of police inaction.
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 According to you.
Correct.
Oh, yes, my lord, police in action, my lord.
So that also is not, the instructions coming have revealed that police is taking some action. They're into investigating the matter.
My lord, the petitioners, my lord, in a compelling situation, my lord, the police is not seen, not in an action, my lord.
So that
Therefore,
where you make before the single bench, we'll remand it to the single bench.
yes, my lord.
Hello.
We see no habeas corpus for the party.
No, not, habeas corpus corona hai.
WP criminal case.
Habeas corpus corona hai. Writ petition only against inaction of the police. Yes, habeas corpus corona hai.
WP criminal लिख दिला ना WP criminal लिख दिया ना
हाँ. देखो, police action. Petition file করার পিছত party বুঝি পাইছে যে নাই পুলিশে কিবা কৰি আছে. May not be successful, but police is doing something. That may also be.
Notice to fill here, no, 31, 12, 24. মাথা গেলে যাব না মানে আমি পেন বলি বলে কম ধরো মন পেতে করবে না কি মনে করে মাথা ছিল এটা করবে না এটা করলে কমন হবে না এটা এসব ফাইল হবে পেলে
Mr. Digdar,
My lord.
essentially your prayer is for compensation.
Yes, my lord.
Compensation.
My lord.
Determine compensation, some investigation, some finding has to be there by the police. We want to know the purpose of filing the petition before the division bench. It is not a habeas corpus petition.
My lord.
It is
We
not
are
a
only
case
on
of-
the police in action. My
It
lord.
is not a case of custodial death.
No,
So it's a case of police action, rather police inaction.
my lord.
So we can close it, giving you liberty to take remedies available under BNSS.
Yes, my lord. My lord, what has been done by the police, that may also reflect, my lord.
That will say,
My lord.
that will say,
My lord.
then we close the matter,
My lord.
giving you liberty to approach the government after some finding is arrived at by during the investigation.
My lord. কি করব পারে হ্যাঁ
One 88, I think so. 188. Bangenda.
এসব গভর্নমেন্ট ওরে লিখতে পারো investigation shall continue. My lord, one thing, my lord, the investigation part of the
Yes.
police may continue, my lord.
Yes, yes. That they will do, definitely. They will do. Take over. কোনে কার্বি আংলং না এইটা কন্টাক্ট এটা মাতিছে না ভিতর চলি আছে ডকুমেন্ট কিবা করবে
হসপিটাল থাকলে পাইব পাইতো হসপিটাল না বাইরে আলাইছে
নেক্সট উইক
Heard Mr. S.K. Sigar, A.R. Sigar, and Mr. D. Haq, all the respondents.
All the respondents.
The petitioner has filed the petition. Agreed that his son, one Anarul Islam, stated to be aged about 22 years, was missing since 13/12/2023. Stop. It is stated that on the fateful day, he had taken out his family vehicle bearing number AS02 AM 5278 within bracket Maruti Suzuki Swift bracket close at about 3 p.m. Stop. After that, he never returned home. Stop. The petitioner, along with other family members and relatives, on search in the evening, located the vehicle at about 8 a.m. on the next day on the Noltoli Road of Koliabor-Tejpur Highway in an abandoned condition. Stop. A wearing apparel used by the son of the petitioner was found lying at a distance of 7/8 feet from the vehicle. Stop. Where are the petitioner accordingly filed an FIR dated when was the FIR filed?
On 14, 14/12.
14/12.
14/12/23.
On 14/12.
19.
So it was filed on 19/12.
Well, it is police has recorded receipt on 19/12, but it was lost on submitted on
According to the
14/12.
petitioner, the FIR was filed on 14/12, but the same was received by the concerned police station on 19/12/2023. In spite of filing the FIR and approaching the police authorities for investigation, the proper steps for investigation and recovery of his missing son has not been stopped. The petitioner thereafter, by communication dated 24/01/2024, addressed a letter to the Superintendent of Police Gurgaon District, ventilating his grievances that in spite of lodging the FIR, the investigations were not being carried out properly and his son has not been recovered. So, since no reply was received, the petitioner has approached this court by filing the instant writ petition with the following prayers. In number 11 and 12 prayer. Notice in the matter which notice in the matter was issued on 26/7/2020. permitting the respondent authorities to obtain a status report in respect of the investigation carried out and apprise the court of the next day. Subsequently, the learned senior government advocate appeared before the court and placed the status report as communicated to him from the concerned OC, from the superintendent, from the office of the superintendent of police, Nogam. So, upon a careful perusal of the communication addressed to the learned senior government advocate, which was placed before the court, it is seen that proper steps have been initiated by the concerned investigating officer pursuant to the lodging of the FIR for recovery of the missing, the recovery of the son of the petitioner stated to be missing, stated to have gone missing. Stop. A supervision note was also placed, supervision note issued by the superintendent of police Nogam was also placed before the court. Stop. In terms of the said note, the actions taken by the IO has been specified, and further, the actions suggested to the IO has also been mentioned in the said supervision. Stop. Pursuant to that, the court observed that from the communication placed before the court, as well as upon perusal of the supervision note, it is not known whether any steps have been taken for publication of the photograph of the missing son of the petitioner in a newspaper and television as per the standard protocol. So, today when the matter is called up, Mr. Nath, the senior government advocate, has placed before the court the information received that through the that the photographs and information with regard to the missing son of the petitioner has been published in two local dailies, namely Dainik Janambhumi in its edition dated 23/08/2024 and the Sentinel in its edition dated 23/04/2024. Okay. Upon hearing the learned counsels for the parties and upon perusal of the pleadings available, petition available on record, it is seen that as extracted above, the writ petition has been filed with a specific prayer, namely to take necessary steps to investigate into the matter and trace out the missing son of the writ petitioner in connection to UPOER case number 49. So the further prayer is for issuance of a writ of mandamus direct the state to pay an amount of rupees 10 lakhs to the petitioner for the loss of life of his son. So, on a pointed query to the learned counsel for the petitioner as to whether he has any information as to whether his son is alive or dead, or whether his body has been recovered from a learned counsel for the petitioner submitted that he has no such instructions. So he submits that in fact he has no instructions as to whether the son of the petitioner in fact, he has no instructions as to whether the son of the petitioner has died in the meantime. Stop. Well, under such circumstances, this court is of the view that prayer for compensation cannot be granted under any of the scheme as may be available or published by the state government of Assam until and unless there is evidence to suggest that the missing son of the petitioner is no longer alive. Stop. From the materials placed before the court by the state, it is seen that the investigation is still underway. The investigating officer / the appropriate police authorities have not concluded their investigation as on date. So, under such circumstances, the prayer for grant of compensation at this stage cannot be allowed. Stop. The other prayer made in the writ petition is for issuance of a mandamus / certiorari directing the respondent's police authorities, more particularly the Superintendent of Police Nagaon, to take care in the matter of Rupohihat PS case number 495 of 2024, to investigate into the matter, to trace out the victim and to arrest the accused persons in the aforesaid case. And upon due inquiry and investigation, to submit the charge sheet. Stop. Better. As have been discussed above, in terms of the communications placed before the court, and upon with due reference to the supervision note issued by the Superintendent of Police, it is seen that the police has taken up the investigation and the steps as per protocol or as per standard procedure are currently being undertaken by the police. Under such circumstances, we hope and expect the respondent police authorities to carry on the investigation in connection with Rupohihat PS case number so and so in right earnest, and upon conclusion of the investigation, take necessary steps as per the procedure of law prescribed under BNSS 2023. Stop. But since the writ petition is filed with specific prayers, and also since under the BNSS 2023, sufficient provisions are prescribed for redressal of grievances relating to in the event of failure of the police authorities to conduct proper investigation. Under such circumstance, this court is of the opinion that since the police has already initiated the investigation and this writ petition, and in the present writ petition, there is no specific allegation, there is no specific prayer, there is no specific allegation that the son of the petitioner was taken into custody and thereafter he had gone missing, or that he had suffered bodily injury or had succumbed to such injuries sustained during police custody. Nor is there a specific prayer for issuance of a writ of habeas corpus. This court is of the considered view that the writ petition can be closed at this stage. So the prayer for compensation, as discussed above, will be available to the petitioner to approach the appropriate authority after the conclusion of the investigation and after the finding of the police authorities as to the whereabouts / the status of the missing son. So accordingly, we dispose of this writ petition at this stage, directing the respondent authorities to continue with the investigation and upon due conclusion, take necessary steps as prescribed under the procedure or prescribed under the procedure of under B and SS 2023. So if the petitioner is still agreed, the remedies prescribed under B and SS is available to the petitioner to approach the appropriate court. Writ petition accordingly stand disposed of. Interim orders if any stand vacated.
But there was no interim. There is no interim order.
That is again a standard procedure.
Development.
Mr. Nafik.
Yes.
Well, in item number 4 on last occasion, Lordship has issued notice, right? I have received some instruction from the SP status report. But I'm awaiting the records, medical documents, FIR, GD entries. Those documents are not provided to me. I have asked for that. Kindly give us some time so that I can file an affidavit and get the instruction, the entire instruction. cordial কথা পাতা হয়। কি হল বলে হবো পাঁচটা রুগী
Mr. Nath,
ভালো
second page of the report,
লর্ডশিপ
second paragraph, third line, second line.
লর্ডশিপ
Second paragraph, second line.
the protesting crowd my lord.
You read it for yourself.
Yes sir my lord.
Second page,
I lordship
start with the agitated.
lordship yes.
The note by the SP.
Possibly they want to
With due
say
respect
no
to that kind of organization.
my lord,
We don't know.
Hmm.
SP has signed it.
correct
Good.
but possibly during that time some ceasefire or something like that is going on. But he should not have used that word.
It's up to you and the SP.
Correct
If in this particular, while putting his signature, he is indifferent, then what will happen with the other matters? It will-
You are praying for some further time.
I prefer for this time my lord, because this comments and this is without any documents or any materials my lord. I have already asked for the medical documents and the reports and all these things my lord.
The vehicle was seized.
My lord, the detailed papers are not with me my lord. Only
You do
this
not have the detailed papers.
no only this report has come. I have already communicated to them that only the report supporting materials documents are required my lord.
Just tell us the last paragraph.
Yes my lord. Since my lord, one person has died my lord, in the firing. The investigation made it clear that beyond the doubt that the last sentence of that second paragraph my lord, they said that police didn't open fire with any malicious intent or motive, but they did so only in the discharge of their duties as police personnel and to save their lives. And therefore, they said that the case was investigated by different independent IOs as per NHRC guidelines, and the incident had taken place as mistake of fact.
Actually, my lord, our prayer was to make a judicial inquiry through District and Session Judge Kokrajhar. Because we do not believe all these reports.
How much time will it?
Lordship may give it 2 weeks time. Let it be after the reopening.
Yes, Mr. Mahmood.
Lord, I submitted that they are dancing like their Lord's desire, man. So our prayer was that the report, judiciary inquiry should be made by the learned district and district judge.
Let him complete his instruction. Whatever he will place before the court, the materials
Yes,
that you see, then we will consider.
Yeah, incident took place in 2013.
Yes,
Now,
that is why.
now they are against a final report.
Yes, because
are
after
the-
10 years, it was fine.
Yes.
After 10 years of the incident. So when it came to our knowledge, we have come to the Honorable High Court.
So now against the final report, they said that they are not agreeable with the finding. So writ petition, whether it is a proper remedy or not, that is also there, my lord.
Have you filed a Narazi petition before the court?
Yes.
What is the status there? You should
It
bring it on
is-
record.
It is, let's see the current. It is going on.
It is already there, my lord. If they have filed.
It is filed, but I have asked them to collect copies. Copies are not yet sent, but they have filed petition. I have been told by the council of the Pokra there.
এই তলৰ কোৰ্টত কি অৰ্ডাৰ হৈছে গম পাই চিষ্টেমটো আছে লগাই দিছে নে নতুনকৈ What is the case number?
One Kazigov is case number 124.
No, no, before the magistrate.
1/1/2000.
GR case.
Here is.
दिया ना यार ना दिया तो दिया ना दिया ना
Seven.
दिया ना यार
Before we test
Which
the-
magistrate?
Yes, my lord.
You received notice from whom? You received notice from whom? Because after filing of the FIR, it was informed
Yes,
by the court.
it was
From which court?
from the court of landed CJM. Pokra.
What is the GR number or the PRC number?
GD entry number was 34. GR number, GD entry number 34, dated 3/12/13. But GR number, I do not see, my lord, that is. Sorry, GR number 1/111. It is 7. Only two cases are there. One was filed by police, another was filed by us. So there are some confusion.
1117.
Final report to conclude the meeting. Final report to conclude the meeting.
Yes, sir. Those are PHPs, 74. Please, নিশ্চয়ই গৈছে। Procedural.
Final report, my lord, GR number is not given. Page 63.
Where is the notice?
yes
Notice, I have not,
You have a copy of the notice with you?
no notice is not with me.
इधर साथी जिसे तो इधर मोटा बनाना कैसे
Yeah, there is an order of the learned CJM that is with us.
यार GR नंबर तो नहीं
In that, yes, in that order, GR number is there.
What is the GN number?
GR number 35/2014.
सीजन ना सीजन को
CJM Kokra.
35.
35, 2014. It's additional CGM. Sorry, but additional CGM. By additional, what is not clearly written?
Six A, capital J. Still, I'm looking at eight. Small T X. System of decision, going in the conflict.
Just pass on the.
PRC was settled.
What happened on 19th of August? What happened?
By receiving notice by the present petitioner, he filed Naraji petition, and that is,
On 19th of August, what order was passed?
that I do not have.
Data, data GA1. More than 30. I.
Last key order.
মাতিব নতুন লিংক করার জন্য লিংক করা দিছে Heard Mr. M. Mandur, Council, Maybe Mahmood, and the council referring to the petition. And Mr. Dean Marshall, and the senior government advocate sound.
Respondent number 1 to 5.
Respondent numbers 1 to 5. And 7.
7. Sorry.
Mr. Not submitted. That he is yet to receive some more information in the matter, some more instruction, information and instruction in the matter, including postmortem report of the deceased.
Next day.
On the other hand, Mr. Mahmood, Planet Council declaring.
But I have received just one information from my junior, that the next case that is fixed on 24/10/24 of the Naraji petition, on that day matter would be heard.
But when they are when the processing is going on,
That's what we are doing.
Naraji petition and all, Malad, this present proceeding ultimately it will have some, it will prejudice, Malad. There is possibility of causing prejudice to that proceeding. Malad.
No, my lord. We have made here three prayers. One is judicial inquiry, second is compensation, third is by a high-ranking officer for a further investigation. So I think
In
that
the previous order, you have heard the order passed by brother, because in the BNSS there are appropriate provisions, right?
yes,
So,
there are three. I
and
have
also
seen.
you are aware, the long back, the Honorable Apex Court has made it clear what are the powers of the magistrate.
Basic grievance is against the FR. FR number,
That matter is pending.
yes,
Malad?
it is pending.
We are making it clear. Listen to our orders first,
Lordship.
that with regard to the affair dated 4/12/2013 relating to Kajigaon Police Station case number 74/2013. Police, after investigating the matter,
Has submitted charge sheet in that case, page 13.
have submitted the search sheet or FR.
Charge sheet, page 13, NHA 5. FR is in the other case. There are two cases. Now.
In our case, police has filed FR, and in their case, they filed the case and filed charge sheet against us. So it
Search
is
sheet
misuse of power by police.
under sections 147, 148, 149, 120B, 341, 353, 427, 323, /352, /207, /365, /511, /435. I've charge sheet लिखे थे ना against the accused persons of the case. While charge sheet number 8/2024 dated 15/03/2024. Where the informant was the sub-inspector of police and in charge of Rupsi outpost under Kajigaon police station. Where is your FIR?
By FIR, my lord, page 56.
56.
Yes, 56.
With regard to the FIR lost by the petitioner, wife of the deceased husband who lost his life during firing made by police the date of the incident on 03/12/2023, being Kazigaon Police Station case number 1/2014. Police submitted. Police, after completion of the investigation, submitted its final report on 31/01/2024 by FR number 07/202. In that regard, Mr. Mahmood, counsel appearing for the petitioner submitted that the petitioner / informant was issued notice by the Court of London Chief Judicial Magistrate, Pokrajat, on 21/06/2024 in case number within bracket FR bracket close GR number 35/2014. And where is your petition? Have you annexed here? Have you annexed here?
My petition before the land court.
Protest
Court
petition
below.
here?
Protest petition
You have not annexed?
not annexed.
You have a copy?
No, I have not that copy.
And the petitioner has already filed her protest oblique Naraji petition in said FR GR number 35 FR bracket 35/2002 pertaining to the final report dated 31/01/2024 submitted by Kazigaon Police by FR number 07/2024 in Kazigaon Police case number 01/2024 it was lost by her. On instruction, Mr. Mahmood submitted that 24/10/2024 is the date fixed for hearing of her said protest oblique Naraji petition before the Court of London Additional Chief Judicial Magistrate, Kazigaon, in said FR number, FR GR number. ठीक है? As the petitioner has already submitted her protest petition before the London Additional Chief Judicial Magistrate with regard to the FR number such and such filed in Kazigaon PS case in the FR TR number. That can be considered monitoring by supervising, supervising usually or can take on the material in the 200 complaint petition. Taking justice in the matter. This court, we are of the opinion, please,
as the magistrate concerned has ample power to give justice to the petitioner on or such protest petition. We close this petition with the direction that
Well, one prayer here. First thing in the charge sheet, the petitioner's name is not there. Agent petitioner's name is not there.
because she is not involved. That's why she is not there.
And secondly, for granting compensation, that is not required, there is gazette notification method. For granting compensation, because here we have made three prayers. One is judicial inquiry, second is high level inquiry, third one is compensation. So Lordship, if Lordship closes the matter, and he was the earning member, and I am on the street with children, so that part may be kept alive. So writ petition may not be closed. So far, the accusation of submitting FR against the erring police officers and others, that may be kept to the wisdom of the learned CGM, but that is,
I think that benefit to be given under that notification of the government
because it is encounter, police encounter.
regarding the date of any such injury, and there is a notification.
My learned friend knows.
Police file. That is an extremist killing. That is an extremist.
No.
For police
That is this.
I think so, it is there.
India.
You have a copy?
Police action বাইরে রাখা যাবে।
Yes, I have a copy.
15/11,
Yeah,
2015.
victim compensation fund. Eligibility for compensation,
That victim compensation is under 357A, possibly 357A. It is a different.
No.
Lordship is indicating about 15/11/2014.
no, you know about
This is
the,
about the compensation scheme by the state.
yes.
There is a compensation scheme, Mr. Talukdar, you might have it.
Scheme is there. This is.
2019 notification.
But
15/11.
this category of that is not there.
That on that point, Lordship may kindly keep the matter for hearing. I'll say, because there is so many cases. One case, my lord, in Borpeta district jail, one person was killed. Another was killed in Chirang. So in those cases, my learned friend confessed.
I never confess.
No,
I
you said
sometimes
you
I
were up
agree.
to 5 lakhs. I remember even that.
What is there to confess?
These videos are open, then definitely. However, I will satisfy on this point. Earlier it was 3 lakhs, now it is 5
There
lakhs.
is another notification.
There is 15/11/2014. There is another, because while Lordship is deciding a matter in case of a person who died in custody, in fact, he committed suicide. Lordship is directed to pay some amount.
That is different issue also.
Following the principle.
During the custody.
Lordship,
That is the
Lordship.
different.
My lord,
But I think there is a
I'll check.
notification regarding firing and all.
Death due to wild animals and all that. Entire list is there. Road accident.
There is a long chart.
15/11 extremist killing and all. 15/11/2014. True. রাজীব বরপুজারি এবং দিছিলে রোবা সত্যজিৎ লিখিলাম সত্যজিৎ এবং লিখিলা রাতুল এই আমার রাজীব বরপুজারি বা সত্যজিৎ मैं जान रहा सर मैं तो कर लूँ 15/11 notification के बाद 15/11/14
Close the search and search. That the concerned magistrate shall dispose of the protest petition filed by the petitioner in said FR, within bracket FR, GR number 35/2014, in accordance with.
15/11/2014 Google 15/11/14 victim compensation scheme.
In the event the petitioner is aggrieved by any such decision of the concerned magistrate in disposing her protest petition as noted above, she may approach the appropriate forum against such order of the magistrate. Needless to say, any such compensation to be paid to the petitioner on the death of her husband during such police firing incident shall again subject to the investigation made by police in a criminal case. To the above observation and direction, this criminal petition stands disposed.
But in that 1511,
That's what brother has actually pointed out here.
in 1511, there is one. my lord. Due to firing of security forces, if the person is killed,
This is 6 December 2014,
my lord,
15/11/2014.
15/11/2014. My lord, there is a my lord, due to firing of security forces, if the person killed is innocent as per report of the Deputy Commissioner SP, Superior of Police
That
Agent.
has to be an investigation.
True, my lord.
Without that investigation, this thing cannot come.
True. My lord, subject to outcome of the Naraji petition.
That's what we have made it clear.
Correct.
It's open for him.
Yes, my lord. So as per the so compensation will come, question of compensation will come after that decision of the additional CGM. my lord. Itu very quick to get. 1511 to 1511.
Just what we've been discussing is that, see, your husband expired during that fire incident.
Yes.
Very with that regard to the FIR that you have lost, it has been made FIR now, right? So there has to be a proper investigation. Only when there will be a finding that your husband has been killed in such and such incident. So that matter has been closed down by filing an FIR. And it is only the magistrate who can pass an order after considering your prayer in the protest petition or hearing. That's why the chances are given to you, whether relief you will get, whatever financial.
No, madam.
will come
Let
under
me say the
order.
procedure. Naraji petition would decide only the guilty of the persons or not.
Naraji
But so far
petition will-
compensation passage under that court has no process power.
Naraji petition will have two things.
Compensation,
is-
but they have no role money. That's
Naraji petition will have this way. First of all, the magistrate will either accept the FIR
Yes.
or on the basis of the material placed before it on the CTF, FR and the other.
Then it will
That is-
run as CR case.
Exactly.
Then it will run as CR case. But
During that
compensation part is not there.
During that procedure, if it is found that yes, such and such enquiry is required, whatever materials is there, or it can consider as an application, there's 200 petition. Recording the statement of the informant
Yes.
and her witnesses,
Yes.
it will come as a criminal petition.
Yes.
During that investigation, it will find that yes, your husband has been killed in such police parade. One such matter is there before the magistrate or any order is there. It will be outcome that you will be entitled for that benefit of, because the notification says police firing and death of an innocent person. So that is how you are, that thing will come out only in that investigation, not here. As on date, we cannot say that your husband was this way, that way, involved or innocent, whatever, right? That is only possible. during
May I
that
say one
investigation.
little thing as I understand, my lord? That whenever this Daradi petition will be accepted and case will run as CR case after examination 200
It
to
cannot, that
Sorry,
both way.
accept, accept.
It's as a complaint petition.
When
only
the
can
case
take
would be taken up for trial by the ladder court below, then we may be given liberty to approach this court for the part of only for
That is why it is open only when it is found that your husband has been killed in such police firing. All the matters will be there, FR will be there,
a long time,
right?
long.
The postmortem report will be there, everything
Yes,
will be there.
postmortem
place
we
it-
do have at present.
You can place it before the magistrate,
The magistrate has no power to grant compensation.
only when that finding is
Only
there, then we
finding,
can
of
come.
course, may be given,
That is,
yes.
I mean, that finding, you can always approach the, that is why liberty has been given to you. There a copy that's over.
My lord, one judgment, 2014-10 SCC,
Hmm.
635,
Hmm.
extrajudicial killing. So that is an independent. So my lord, my only humble.
We are doing it for your good.
No, it will after 3 years at present, my lord, and on the street. Because my husband was the sole earner of the family.
Yeah, understood.
And due to his killing, we are on the street. And I am a lady with,
Well, in fact, it is 10 years. They waited till the FR.
no,
They know that.
we are
they
expecting
know.
justice, but after 10 years, you have closed the justice, so we have approached.
Only thing is that she'll be entitled for compensation when it is
No.
found that he died of police
Yes,
firing.
yes.
That has to be
Yes,
there
yes,
by
yes,
some
yes.
inquiry.
Yes, that
Yes,
is the main
correct,
thing, madam.
correct.
That is the
Otherwise,
main thing.
petition of that, can't think of that benefit.
Had there been a
But
charge
if
sheet.
I get better judgment on this point, I will file review petition, madam.
Hold on. Have given a
Okay.
caveat.
All right.
May I please, Your Lordship? My original and actual name is Jahanara Parvin, Your Lordship. Notice was served as Jahanara Begum. Therefore, my admit card was discarded, Your Lordship. Imping order, Lordship will find at page 52. Page 56, para 12, Your Lordship. My admit card has been discarded. And in WS, it is also stated that OP will contest the case as Jahanara Parvin, Your Lordship.
जैसे एक लिखा है नहीं नोट मेंशन
My husband name is written correctly, my father's name is written correctly in the notice also. Therefore, I appeared and I submitted all the documents related to Jahanara Parveen.
Have not annexed the admit card. Na? Admit card annexed for another. जाते ना जाते ओके 70
7.
2005 January paper. And about January for period. So how do you see it from after? I guess Jahannagar or Papino have given right individual people. They will be the Chinese solution of the Papino. ঠিক আছে the patient should go. The patient should go. Ya te quieren que the patient will go Papino to care. I would just wish Papino. I would just wish Papino.
Yes, Ms. Verma.
Yes, Lordship. Lordship may kindly come to the WS. She has stated that there are 10 siblings, Lordship, altogether, and their parents, but I have not found a single voters list of all of them together. And she was born in 1981. I was just trying to connect that to her other siblings. And in one voters list, she is Jahanara Prabin, and in one she is Jahanara Begum. And there's no explanation to that except a self-made statement that we're one and the same person, Lordship. And not a single voters list with the parents' lordship of other siblings also.
Yes, yes, ma'am.
Lordship, I have stated that she has 10 siblings. Not a single voters list is connected to her parents' lordship. And though she is born in 81, she is referring to documents of 66 and 71, and those have not been proved lordship. The voter list which has been exhibited. And regarding the admit card, which my friend says that it has been discarded, it is she who is making a statement that Jahanara Begum and Jahanara Praveen are one and the same person. There's nothing else to prove that they are not one and the same person, lordship. And whatever documents are there, it is with the husband, not with the parents' lordship. Only on the basis of
Certificate was not proved, school certificate.
no lordship.
Lordship, in WSF paragraph 27, I have stated that I am Jahanara Parvin and I will contest as Jahanara Parvin.
No, but lordship, when the records come, we will know what was the name she had given during the time the form was filled up.
What is the basis? What is
Yes.
the link document?
Admit card, Your Lordship.
But it was never proved.
Lordship.
Hmm?
Only
Documents
admit
were
card.
never proved. Mere production of the document is not sufficient.
Lordship.
You know that. So, where is the infirmity in the order? Tribunal found your documents are not reliable.
Lordship, an admit card is maybe a public document. I think it may not be necessary to.
Somebody has, you know that.
Lordship.
It is your burden to go and call for the officers, get the records, place it before the court.
Lordship, then allow me, I'll
Allow you what?
contest to prove this document.
That is not the mandate of the.
Mother also came and deposed, Your Lordship.
That is the only statement, but that is again not supported by any document.
Any document, lordship.
You have 11 siblings.
Okay. Just see what you have done by yourself. You are asking for a chance, right? Come to page number 27 of your written statement.
Lordship.
Read para 19
Yes, Lordship.
Read.
That her father Hussein Ali was deceased in about 62 years.
Ago. Right? Now, please come to page number 30. Or page number, page number 30.
Lordship.
You have signed this affidavit on 38th of June 2023. So 2023 minus 62, 1961,
Lordship.
right? This is your statement.
Lordship.
Now, please come to the statement of your projected mother at page either at 50 or you can come at 51. Whichever you like to read, you read.
My husband passed away in 1999. My
That's
father,
your projected mother has said.
Lordship.
And you have said your father expired in 1961. Now, the voter list of 1966.
Lordship, kindly
That
please
is
come to page
1966.
Lordship.
66. His name existed in the voter list of 1979.
Lordship.
Your annexer, it is all your documents because you are proving, right? Your father's name figured in the voter list of 1985.
Lordship.
But you said your father expired in 1961. Your mother said, your projected mother said your father expired in 1999. And voter list contains the name of your father up to 1993.
Lordship, in page 27, it probably written as was deceased in about 62 years age. Sentence may be 62 years age of age it would be, I think.
Sharma.
Yes, at that time, please.
Ago लिखा है सर,
Ago.
about 63 years ago.
Ago.
This is a wrong statement, Your Lordship.
It's your case.
আমি এটা বললাম দেউতাকৰ বয়স 66 দেউতাকৰ বয়স 66 32 হয়
Ago,
61 ঢুকাই
years ago.
আৰু single name voter list.
There are discrepancies in the age of Hussein Ali. In 1966, Hussein Ali was 32 years. Even if we accept in 1966, said Hussein Ali was 32 years, his birth year would have been 1934. And in 1999, he would have been
Lordship, there are
65
some
years.
discrepancies,
So
I admit.
that's all.
Lordship, but in page 27 regarding the statement of father's death, Your Lordship, may be wrongly stated by the
Which is the
person
link
who
document between you
drafted.
and your father?
Lordship,
Which is the link document?
admit card.
How you have proved that?
Has not
That has
proved, Your
not
Lordship.
been proved. Lord.
How you have proved that? But mayor producing a document is sufficient.
Lordship, since it is issued by a competent
Just
authority.
tell us in which school you have studied, where you have mentioned in your written statement.
Not mentioned.
Not mentioned.
We are giving a document as a proof of citizenship like that.
Probably it is Colors or high school, I think. If there is
Where you have seen which particular paragraph you have mentioned?
any written statement, is not mentioned here.
Lordship, 2005 voters list shows her as Jahanara Begum, and before it's Jahanara Praveen, just a mismatch of documents, Lordship, to come to the.
I have
to
stated
prove a
in a
citizenship,
written
Lordship.
statement about 2005 voter list, Your Lordship.
But so many aliases cannot give them one PAN card, one Aadhaar. That means they must be having two PAN cards, two Aadhaar cards, Lordship, in both the names. Yeah.
Hypothetical question level.
তোমার কন্ট্রোলার একটু কিছু হেরি না
Lordship, there are some discrepancies by prima facie. I have,
First of all, the link document you are supposed to prove, Mr. Counsel.
I will satisfy next date, Your Lordship. Protection may be given and fixed for hearing, Your Lordship.
That is the link document, as you have stated, is your HSLC certificate, right?
Lordship.
That is the reason we are asking you how you have proved that link document. Your mother saying will not do, that the law has already been settled.
All the voter list I have,
But
regarding my father, I have submitted, exhibited of village color, sir. And the admit also in color, sir. It is written in admit, it is color, sir.
You have to point out the anomalies in the order. What way, how the evidence has been applicated, whether any evidence has been left out. Let's do that. Why do we exercise the jurisdiction to reappreciate the evidence? We can't do that. We should not do that.
Okay. So I have submitted all the public documents, Your Lordship, exhibited all the documents in the public.
Not
But
enough. You know the
all are,
judgment. You show us one judgment where
Discard.
submission of the document, public document,
Lordship.
burden shifts to the tribunal to call for the officers to prove the
Lordship.
document in your favor.
I'll satisfy, Your Lordship.
What is there to satisfy? Records are here. We don't
Lordship.
find any application on the basis of which you are called for your the raid before the tribunal to issue summons. Then what is there to be satisfied?
Lordship, give me one date, I'll try to satisfy Your Lordship. Regarding this issue, Lordship has raised.
issue is simple. You have to tell us which you have paid. Why the order of the tribunal is blank. The tribunal finding why it is bad, whether it has wrongly done erroneously has done that thing or perfectly done something. Where is it? The document that you have placed have not been proved, simple. And you have not proved. Now before the High Court, you cannot prove.
Lordship.
So
Lordship, next day I'll try to satisfy you.
how will you prove? Your only link document is your admit card,
Lordship.
right? And you have not proved that document. Would have considered. See, in your written statement, you have not even mentioned the name of the school in which you have studied. From whether you have passed or not passed, that is a different issue.
Lordship.
In which school you have studied? To consider that admit card.
Lordship, another date may be fixed and in the meantime, protection may be given since she is a woman. Your Lordship.
We'll give you all the protection in the detention center.
Lordship.
Let us dismiss your petition, we'll direct the authorities. to do the detention center. We'll give you protection from being deported. Till some time.
Lordship.
Let me to continue.
Lordship, in such situation, in earlier occasion, the coordinate bench, Your Lordship, has remanded back the matter to prove a certain documents. There are
Lordship,
some order. I will.
Come to page number 76, my brother has pointed out.
Lordship.
Come to page number 76.
Lordship, I.
Your admit card,
Lordship.
where is the signature of the controller of SEBA? You have some kind of different kind of officer in search. Kalach or higher secondary, high school living certificate examination center. So that itself, that is maybe the reason why you have not proved that document. Can there be an admit card without being issued by the authorities in SEBA?
Lordship, I will include the matter and
Question,
take an
Giving me
step.
another chance doesn't arise. You have not proved this document.
Because I don't have the
The
original.
reason is
I
simple.
don't have the original. I have the certificate copy, Your Lordship.
Original is here.
Lordship,
Original is.
the record, Your Lordship.
You want to say it? Yes, Miss. Verma, look at it. This is a document without the signature of the controller of SEBA.
The initial cutting.
And that is why it was not proved before the tribunal.
Lordship, on this admit card, I would just like to place one citation which will take care of it, Lordship. This is Narmada Devi Gupta, Lordship, versus Birendra Kumar Jaiswal. This citation is Lordship
Narmada Devi.
Gupta
Hmm.
versus Birendra Kumar Jaiswal. Paragraph 16, Lordship.
Our High Court judgment.
No, Lordship, it is not our High Court, it is SCC judgment. Lordship, I will.
What is the respondent's name?
2003, 88745.
2003, 8 SCC 745. It is a Supreme Court judgment, Lordship.
745,
745.
2003.
2003, 8 SCC 745. What is my record?
2003, 8 SCC, it's not showing.
745, Lordship.
2003, 8 SCC.
Yes, 2003, 8 SCC 745.
My God. More than- Yes. Where you want to show?
Paragraph 16, Lordship. Paragraph 16 is reliance is heavily placed on behalf of the appellant, so the legal position is not in dispute that mere production and marking of a document as exhibit by the court cannot be held to be a due proof of its contents. Its execution has to be proved by admissible evidence, that is, by the evidence of those persons who can vouchsafe for the document of the facts and issue. The situation is, however, different where the documents are produced, they are admitted by the opposite party. Signatures on them are also admitted and they are marked thereafter as exhibits by the court. Lordship, another judgment in the same judgment, Lordship, I do not know the paragraph there. I'll just. Lordship will give me a moment. In Rashmi Nara Begum, Lordship, 2017, 4 GLT 346.
4 GLT.
4 GLT 346.
2000.
17, 4 GLT 346. Paragraph 31, it's the same matter which, same reference, Lordship. Law on this aspect is very clear in Narmada Devi Gupta versus so-and-so. Supreme Court reiterated the legal position that marking of documents as exhibits and their proof are two different legal concepts. Mere production and marking of a document as exhibit cannot be held to be due proof of its contents. Its execution has to be proved by admissible evidence, that is by evidence of those persons. Paragraph 31, Lordship. Then paragraph 32 also. Paragraph 31 has Lordship found it. It is on the documents which were exhibited before the tribunal and those were not proved. And these judgments are on this proposition, Lordship. They were simply filed in the tribunal, yet from the perusal of the impugned order passed by the tribunal, we noticed that notwithstanding non-exhibition of the documents, tribunal had considered those documents. These were considered, but the opinion went against them. Paragraph 32, Lordship. This proposition was again restated by the Supreme Court in LIC versus Rampal Singh, wherein it has been held that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is required to be done in accordance with law. Under the law of evidence, it is necessary that contents of documents are required to be proved either by primary or by secondary evidence. At the most, admission of documents may amount to admission of contents, but not its truth. Contents of the document cannot be proved by mere filing in a court. Such a document cannot be relied upon.
Okay.
And even paragraph 33, in the present case, none of the documents referred to by the petitioner were exhibited, not to speak of being proved. These were simply filed before the tribunal. Paragraph 31, 32, 33. I will be relying on this lordship.
That's the law, by placing the document is not enough.
Yes, lordship. Mere collecting and documents and marking them as exhibits does not give them the claim of citizenship, lordship.
Anything else you like to?
And again, the bit of surgery which we would like to place, that is their lordship, yes.
Justice Paldiwala does not.
Yes. Santlal Gupta.
And in fact, to go to their judgment, the issue in that petition was different,
Yes.
that appeal involved, but the lordship have separately dealt with the certiorari only because
And they can,
in that matter also there was something was involved. So lordships have dealt with this matter only on certiorari in that way, considering all those aspects in so many years.
yes, lordship.
Any reply?
Lordship, only my humble submission is that another date may be fixed.
What will you do? But indeed, did you prove that document before the tribunal?
No, I have not proved here.
You have not proved where is
This
the
is admitted
validity of
fact.
the order of the tribunal.
This is admitted fact.
So
I'll try to satisfy your lordship with legal purposes.
Tuesday. Tuesday next.
Wednesday, your lordship.
You asked for something, we gave you, now you're bargaining.
Okay, lordship.
Tuesday.
Your lordship.
Lordship has taken a note of my judgments,
Everything
lordship.
is there.
Yes,
You will only
lordship.
reply. That's- If anything is to be netted, you'll give you a chance.
Yes, lord. Tuesday date, yes, sir.
Yes.
May I have permission to mention, my lord? Lordship, today my item was listed before Honorable Court 12, my lordship.
Yes.
But due to a special bench, my lordship, the bench could not assemble. My lord, I am seeking a date, my lordship, where I would be available before this Honorable Court, my lordship. I have to come from Delhi, my lordship, to attend this case. So if possible, my lordship, 22nd October after vacation.
You are appearing for the respondent.
Petitioner.
Okay.
Respondent
not
counsel
on
is also here,
22nd.
my lord.
It came for hearing today.
No, Lord.
It was
Lordship,
listed for-
they have given chance to file objection, but they have chosen not to file, my lord, in spite of the time. The second round of litigation, my lord.
On 23rd,
23rd.
because 22nd is Tuesday, it's a hearing day.
Yes,
You
my
have
lord.
it on 23rd.
Obliged, my
You
lord.
are appearing for the other side.
Respondent, lord.
Please, your lordship.
Declare of the council for the parties list on 23rd. October.
My lord, item number 1 and 2 was, my lord, transferred for the time being, my lord. The same petitioner, my lord. The item number 1 was during the pendency of the first writ petition, the second proceeding was started, my lord, for which the second writ petition was filed, my lord.
Two different tribunals.
My lord, same tribunal.
Same tribunal.
Same tribunal. This stayed, my lord, by this honorable court.
We'll have it on Monday. Monday.
Obliged.
Item number 7, your lordship, as soon as possible, any date may be fixed, your lordship, before vacation.
These matters are for motion. It will come
Motion,
again
motion.
next week. This that you have.
Yes, sir, I have received.
No representation on behalf of the petitioner. On call. Petitioner. The names of three councils for them have been reflected in the court list. Part Mr. P. Sharma, London referring for the state, who is having the relevant up-to-date case diary. List on 38. Mr. Sharma, the concern up-to-date case diary. Already received by the Land and Property Prosecutor, shall be retained.
I plead a lot.
Why does it list before the?
Listed because the main accused lordship have granted bail lordship. For that reason, listed before this. Hence.
I think we'll dismiss this petition.
Lordship,
We should dismiss this petition.
why lordship?
Read para 1 and 2. Read loud. Read,
1 and 2 lordship.
read loud. Read para 1.
That the petitioner is a citizen of India by birth and permanent resident of the aforesaid address mentioned in the cause title of the petition, and as such is entitled to get all sort of rights and privileges and benefits granted under the Constitution of India and other laws. And the petitioner businessman by,
Read, what is it?
the petitioner is a businessman by profession.
Read para 2.
The petitioner begs to state that he is a government employee and presently working as law model in the office of the district magistrate.
So
And
tell us, should you not dismiss this petition? You are seeking bail.
I'm sorry, lordship.
Sorry, you will not do, Mr. You have seen, you have read, and that is before the court. We don't know. It's your statement. So you will not accept it. We have nothing to say. Your petition. So which one to believe? Which one to consider?
We'll file a fresh lawsuit.
We don't know, up to you, Mr. Munir, up to you.
No,
He
withdraw
is
it, Lord.
seeking PRS bail in a CID PS case and filing like this. Up to him. He has signed. He's not an illiterate. So why should you consider him?
I'm also going to withdraw it, Lordship.
You go.
We'll
See,
Put a liberty to file a fresh.
what is liberty in PRS bail? Where it is given is the writ petition.
No, no. So we'll file a fresh.
Tell us this thing happens.
I'm sorry, Lordship, extremely sorry. We did not,
Mr. Munir, counsel appearing for the petitioner submitted. There are certain inadvertent mistakes in this PRS bail application. And press for withdrawal of this, and is not withdrawal of this. So that he can file. Appropriate application. Put out any such mistakes seen in this petition. You can file it, then appropriate application. But I allowed. But you can cancel. Dismissed on.
please, sorry,
To
Lordship.
which Mr. B. Sharma. Has no objection.
I'm extremely sorry, man. Much obliged, your Lord.
Mention of sorry will not do, Mr. Munir. Is this somewhere?
For reasons mentioned in the judgment, this writ petition is dismissed. For reasons mentioned in the judgment, this writ petition is dismissed.
Praise the Lord.
Correct. This writ petition is dismissed.
Maybe.
For reasons mentioned in the judgment, the case number FTDC 665/2016 is remanded back to the Foreigners Tribunal 7 Sonitpur for ascertaining as to whether Sati Bashya alias Sati Mitra and Saraswati Bashya, wife of Pratibal Bashya, are the names of one and the same persons or not. The tribunal may allow the state to adduce evidence to show as to whether Saraswati Bashya and Sati Mitra are one and the same person. In the event state adduces any evidence in this regard, the petitioner may also be allowed to counter the said evidence by cross-examining the witnesses and by adducing her own evidence to show the petitioner is not Saraswati Bashya. After ascertaining the aforesaid facts, learned Foreigners Tribunal Sonitpur shall render a fresh opinion in this regard to the reference made by Superintendent of Police Border Sonitpur. Consequently, the impugned opinion / order dated 5/9/2018 passed by learned member Foreigners Tribunal 7 Tejpur is hereby set aside and quashed. The petitioner as well as state respondent shall appear before this said tribunal in case number FTDC 665/2016 on 28th October 2024 at 10 p.m. 10 a.m. 10 a.m. And the petitioner shall submit a certified copy of this order before the said tribunal. For reasons mentioned in the judgment, the impugned order / opinion of the learned Foreigners Tribunal number 1 Moregaon with regard to the nationality of petitioner number 2 to 6 is held to be illegal and without jurisdiction, and therefore same is set aside and quashed. As regards petitioner number 1, we do not find any ground to interfere with the finding of the learned tribunal. And accordingly, with regard to petitioner number 1, this writ petition is dismissed to that extent.
Published.
For reasons mentioned in the judgment, this writ petition is dismissed. For reasons mentioned in the judgment, this writ petition is allowed. The Home Department, Government of Assam is directed to pay a compensation of rupees 3 lakhs to the petitioner, namely Sabura Khatun, who is the wife of under trial prisoner Rohizuddin Sheikh, in her bank account within a period of 2 months. The compensation amount is to be deposited in the bank account of the petitioner on proper identification within a period of 2 months from the date of this order. For reasons mentioned in the judgment, this writ petition is dismissed.
Item number 9 to 20.
Yes, part.
My lord, in item number 18, there is an interim order, my lord. Let me kindly. Yes. Will, my lord. All right.
For all these orders from 9 I have to take up the
Argument, yeah.